You may be seated. We want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have three interesting cases, a group of very good lawyers, and I know we have several guests from Virginia Military Institute, and we welcome you to Richmond and to the Fourth Circuit. In the first case, Juanita Cavendish versus the Director of the Office of Workers' Compensation Programs, it's what we call a black lung case, and it's being handled for the applicant widow by the Washington and Lee University Law School. Ms. Burgess?
Yes, Your Honor.
Mr. McDonald, you're going to introduce her. Yes. I'm sorry. It's the supervising attorney. This is the lawyer in charge of the program.
May it please the court. My name is Tim McDonald, and I represent the petitioner in this case, Mrs. Juanita Cavendish. It is my pleasure to introduce to the court Ms. Annalise Burgess, a third-year student at Washington Lee University School of Law, working in our Advanced Administrative Litigation Clinic, and she will be presenting oral argument on behalf of Mrs. Cavendish today.
Yes, sir. We appreciate your service, and we look forward to the service of the students, and we look forward to the argument.
Thank you, sir.
Ms. Burgess.
I'm impressed by all the documents you've brought up. We're hoping you don't have to use them all.
I was told, or I thought you might make a joke about it. May it please the court. My name is Annalise Burgess, and I'm here representing Mrs. Juanita Cavendish, the appellant in this matter. Mrs. Cavendish is before this court asking that the decision and order of Administrative Law Judge Patricia Dahm be reversed and remanded with instructions to re-examine the evidence in this case as to total disability. Judge Dahm's decision and order was irrational, not based on substantial evidence, and it is in fact contradicted by the evidence of record. In a black lung claim, a claimant must establish that they are totally disabled from pneumoconiosis or black lung disease. Total disability is described in the regulation in the following way. If a minor has a pulmonary or respiratory impairment which standing alone prevents or prevented the minor from performing his or her last coal mine work, thus central to the determination of total disability is what were the physical demands of the minor's last usual coal mine job.
So what's our standard of review here?
Your Honor, it's a standard of substantial evidence. What you're looking for here under Consolidation Coal Company v. Held is whether or not the judge's determination of total disability and all of her determinations in this case were supported by substantial evidence and if they are rational. Substantial evidence means more than a mere scintilla of evidence. And in this case, what Judge Dahm did was she took a single form and discredited all other evidence of record that Mr. Cavendish completed light to moderate work with occasional heavy
Which form are you
exertion.
talking about?
We're talking about the CM-913, Your Honor.
The 913?
Yes, it's a lot of numbers, but the CM-913 is on page JA-159.
That's the claimant's application for benefits.
It's one of their initial filings.
What about the
in
911?
Yes, Your Honor. So the CM-911 is a different form. That's an employment history form.
That's a claim for benefits, too.
Yes, so there's a few documents that are submitted at the initial filing or during that initial phase.
Were they submitted together, the 911 and the 913?
No, but they come almost directly after each other,
Wait,
to my
wait,
understanding.
in connection with the same claim?
Yes, Your
Or
Honor.
in connection with the same claim? Well, how long did the decedent, Mr. Cavendish, he's deceased now, right?
Yes, Your Honor.
How long did he work in the coal mines?
He worked in the coal mine from,
The coal mines, he was a coal.
yes, Your
He
Honor.
worked for lots of coal companies.
Yes, so he worked in the coal mines from 1964 to 1997, when
For
he,
33 years,
yes, Your Honor.
okay? And he worked, how many of those years were underground mines?
Your Honor, I don't have that number directly memorized, but I am happy to go through and calculate that for you.
Well, looking on the 9/11,
Yes, Your
he
Honor.
went to work for Birch Coal Company in 1964. And he worked underground after that for 8 other coal companies up through 87, and then you turn the page, and he worked at the coal tipple for 5 months. That would be outside.
Yes, Your
All
Honor.
right, that's not underground. Then he went back to work underground in 1989.
Excuse me, Your Honor, I forgot this had been previously
see,
calculated,
Yeah, that's what
but
they
it's
do.
16.
That's what, they work, these fellows work underground, in lots of them, patterns, and when that's harder work than working on the surface sometimes.
Yes, Your Honor, sometimes.
That's right, and the air's better.
Yes.
So he worked, it appears from that form, at least 23 years underground,
So what we have.
underground, before he
what we've-
worked anywhere on the surface.
Yes, Your Honor. So what we've presented actually to the Benefits Review Board and to the lower court is that he worked for 16 years in underground coal mines
But
and
he worked for 23 years according to this form.
Your Honor, the way the form is actually calculated, it's based on essentially, there's a calculation under the Act. And the calculation under the Act is, did you work for X amount of time during each year? And based on our calculation, it's 27 total, and 16 of those were underground mines. And I don't know.
But how do you account for the fact that underground mining is more than 16 years on this form?
Your Honor, I don't know how we account for that.
Maybe there were periods of unemployment.
Definitely possible, Your Honor.
Maybe they had coal strikes. Maybe didn't go to work. I don't know, but I'm just looking at the form, and it just goes underground, 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 underground. And I'm always, in these cases, are interested in whether they worked underground or whether they worked above, on the surface, because the underground's where the more coal dust. The breathing is rougher. And that's what
Your
causes,
Honor.
that's one of the big causes of these fellows getting black lung.
That is true, Your
Matter of
Honor.
fact, he worked before, several years, according to this form, before the Black Lung Act was adopted, and before they implemented coal safety rules, the more stricter coal safety rules, which resulted from a terrible, terrible coal mine explosion in West Virginia in 1968. And this guy had already been working underground for 4 years when that happened.
Yes, Your Honor. What's at issue today, however, is this issue of what were the physical demands of his job. And it has to be what was the physical demands of the last usual coal mine work. So that means the last 2 years.
And that's where he was
of
the
his
dozer
job.
operator,
Yes, Your Honor.
above ground.
Yes, Your Honor. So that's what
Okay.
it's at issue today, is whether or not that job was light work.
And
But
Counsel,
don't they have to understand how long he worked underground and how many years he'd been a coal miner?
Yes, Your Honor, but not
Is
for.
that relevant to something?
Yes, Your Honor, but not to an element that has been decided today. What's been decided by Judge Dahm is solely the single element of total disability. And for that reason, we didn't even get the chance to argue the things you're talking about right now. And what we'd like today, Your Honor, is for this case to go back so that we can see what the ALJ would have to say about those things.
Counsel,
Well,
can I,
where-
sorry, go ahead.
Where is that in any of your briefing? I mean, I thought this case was solely about total disability due to a back injury. This is the first time I recall seeing anything, either at the ALJ, the BRB, or here, about some prior cause of disability.
Excuse me, Your Honor, I think there's a few disabilities that Mr. Cavendish has. Mr. Cavendish, yes, he hurt his back, but that only resulted in a 26% permanent partial disability.
Right, but what all that may be correct. What I'm asking you is, where have you brought that up in this case?
That Mr. Cavendish is totally disabled
Well,
from black lung disease.
the total disability, as you just described it, was his injury while he was a dozer operator. All right, that's in the ALJ opinion, that's in the BRB opinion, that's what you briefed here. I'm not recalling anything about prior work as a cause of disability.
Your Honor, what we're
So
looking...
what I'm asking you is, where is it?
Yes, Your Honor. So we've presented evidence that Mr. Cavendish had a pulmonary or respiratory impairment, which is the only thing that's required under total disability, is that you have a pulmonary or respiratory impairment. So we presented evidence that that Mr. Cavendish has a pulmonary or respiratory impairment, not black lung disease. We have presented evidence that he has black lung disease in particular, but for this single element that was decided that we're talking about today, we're just talking about a pulmonary or respiratory impairment. And if he has one, then we have to look to what the physical demands of his job were. And so with the physical
Which is there evidence, pro or con, that he can operate the bulldozer?
Yes, Your Honor. It's what does a bulldozer operator do and what are the physical demands of that job? Yes, Your Honor.
And what is your answer to that question? I know you think the ALJ was wrong in saying light, but what is your view of what the correct answer is on this record?
Light to moderate work with occasional heavy work exertion. We
Okay.
presented evidence. We presented Dr. Sood's expert opinion, Dr. Allen's expert opinion. We presented 2 state claims, which in their finding of fact say that Mr. Cavendish had to lift a dozer battery and that he hurt his back lifting that dozer battery. And then
So counsel, if the ALJ, say, were to accept the wife's testimony that there was occasional lifting of batteries, would that get you, is that sufficient evidence in your view to show that the right exertional level is light to medium and occasional heavy?
Yes, Your Honor, but we don't believe that's the only evidence.
No,
on
I know,
this
I'm just
record.
trying to figure out how often he'd have to be lifting this battery. If it's just like twice over the course of several years, is that enough in your view to get you to occasionally heavy?
If Mr. Cavendish had to lift a dozer battery at work,
Ever?
then
Once?
he is totally once,
Okay.
twice, yearly, monthly.
But once would be sufficient in your view?
Yes, Your Honor. If Mr. Cavendish ever had to lift a dozer battery at work, he would be totally disabled under the regulation because the regulation states that the physical demands are central to determining total disability. We can imagine it like a hurdle. When the hurdle, for instance, if a person has severe COPD and they're a coal miner, when they go to prove total disability, they can probably still do a sedentary job, right? And so the hurdle is going to be really high for them to decide, for them to be able to prove total disability. But if that same person with severe COPD is going to show that he has a light to moderate a job with heavy work exertion, that hurdle is going to be lower because that job is hard and a person with severe COPD could not do that job, so it's
So
easier for them to prove.
What's your best evidence of that?
Yes, Your Honor, so there's a few pieces of evidence. We have the state claims. The state claims show, JA 181 and JA 184, show that Mr. Cavendish hurt his back so bad lifting a dozer battery or helping to lift a dozer battery. The state claims differ in their findings of fact on that. That he hurt his back so bad that he received a permanent partial disability for that lift of a dozer battery. We also have Mrs. Cavendish's testimony. Mrs. Cavendish testified on JA 775. She testified that that her husband, on occasions, is the quote, on occasions, had to lift dozer batteries at work.
Which the ALJ said was hearsay, which could be acceptable, but it's not required.
What is required, yes, Your Honor, you're correct. What is required is that she look at the evidence and that she review it. And you can't just dismiss evidence because it's hearsay. And that's what the ALJ does, is she looks at that evidence, Mrs. Cavendish's testimony, and says it's hearsay and therefore non-credible. And then what she does additionally is she says—
None of these witnesses testified live.
No, Your Honor, all of these
This thing's
yes.
decided on the record.
Yes, Your Honor, they
There
are all
weren't any
depositions.
witnesses brought into a hearing room or a courtroom and testified.
Yes, Your Honor, that's correct.
Both sides stipulated the judge tried on the record, like a bench trial solely on the paperwork.
Yes, Your Honor, that's correct.
So everything was hearsay. It's all written out.
It was all written out, Your Honor.
I know.
I'm not sure if, because of the rules, I'm not exactly sure if it would be hearsay.
There
But
wasn't any live testimony. There wasn't a single witness presented to the IJ or the AJ.
That's
ALJ,
correct.
whatever you call them.
in the ALJ hearing, though, hearsay is admissible. And so it's pretty common.
Hearsay can be admissible, and it can be admissible in the trial of a murder case. Depends on the exception.
Yes, Your Honor.
Here, it was a cold record. No witnesses came to court.
This is correct. And one of the things I just want to talk a little bit about what Judge Agee had talked about, the CM-913, what Judge Dom does is she finds evidence on the CM-913 that's just not there. She says there are assertions on that form that are not there. She discredits Dr. Allen's opinion. Dr. Allen is the DOL examiner, the Department of Labor examiner.
So why do you say that about the form? I'm looking at it on JA 159. So this is the original claimant's declaration. And he says, you know, what do you do? Surface strip mining. My dozer operator had to climb up into the dozer about 8 feet, and I sit for 8 hours a day. I mean, that's the evidence in effect from the claimant.
Let me read a quote for you. I think it would be helpful. This is Judge Dom's opinion on J043. In effect, as detailed in the claimant's CM-913 form, the claimant did not walk around the work site for anywhere near 8 to 10 hours a day. If you're on that page, you'll see Mr. Cavendish was never asked how much he walked. Additionally, he was never asked, the second question here is, nor did he constantly climb in and out of the dozer. That's Judge Dom's quote on J043. He did not constantly climb in and out of the dozer. Nowhere on this form does it say how often Mr. Cavendish had to climb in and out of the dozer, Your Honor.
So what difference does that make?
It makes a difference because if you look at what she's saying it's detailed in the CM-913. And she also says this when she discredits Mrs. Cavendish. She says, the quote is,
Well, the reason I asked that, I've climbed in and out of more than one bulldozer, and it's not that hard.
Your Honor, Dr. Sood testified as to what a coal mine bulldozer operator does. In a coal mine, he said that—
This is a surface mine. It wasn't
yes,
in a
Your
coal
Honor.
mine. It was a surface mine.
Yes, Your Honor, it's a surface mine.
One of these big is a big, big dozer.
Yes, it took 8 feet to climb up into. Dr. Sue testified to what the other duties of what a bulldozer in a coal mine operator position does. I see my time's about to expire, but I just ask,
That form also on the next page lists his other coal mine employment.
yes, Your Honor, it does.
And starting in 1964 as a general inside laborer. And all those are underground mines, operations, job titles listed. I believe, starting in 64 and going up to 1990. He worked underground for all this time. And there's some kind of a statutory 15-year presumption on having this black lung. If you work underground for 15 years, you're presumed to have it, right?
Your Honor, there are presumptions in this case. What we're talking about here, though, is total disability,
Yeah.
and so we haven't gotten into that subject matter on this appeal, and we haven't argued that in our brief. I'm sorry.
Thank you very much.
Thank you.
We appreciate it. Let's see. If I could find my paperwork, Mr. Green,
Morning, Your Honor.
good to have you with us, Mr. Green.
Thank you, Your Honor. May it please the court, Christopher Green, appearing on behalf of the respondent, Landmark Corporation, as insured by the West Virginia Coal Workers Pneumoconiosis Fund. Your Honors, ALJ Dom considered and weighed all the evidence.
Can we start with the form, counsel? Because it did seem like the ALJ put a huge amount of weight on this form. And I'm not really seeing how you can read this form as the claimant saying he did not occasionally lift heavy things, because all it asks for is whether you lift things daily. So I don't understand how you can read into this an assertion that not only do I not lift things daily, but I also don't lift things occasionally.
Certainly, Your Honor. There's a
Yeah.
couple points I'd like to make about the form. First, it does ask for information about other than daily work. Without limitation.
Are you at 159 or something like that?
Yes, Your Honor. And then if you go to page 160, the next page, without limitation, it asks if the miner's most recent job involves the use of tools, machines, or equipment.
But that's not the same as asking if you lift things.
In order to lift things, to work on a battery, you would need to lift tools to do so, Your Honor. In order to work on a machinery, you would need to be lifting those items. There was talk about all this maintenance that was done. In order to do that, you would need to use tools to do the maintenance and to get the battery out, Your Honor.
And so
Additionally,
the concern is, because he did say, yes, I do tools, machines, and equipment, but he didn't write in, and I occasionally lift batteries between 75 and 100 pounds. You think this question called for that answer?
it would also, Your Honor, and additionally, he marked yes, but didn't identify anything other than a bulldozer operator. And finally, the form also has a catch-all at the end where it asked the individual to provide any other information they feel would be helpful. And there's also been this inference that, well, Mr. Cavendish had a limited education and it would be unreasonable to ask him to go beyond the form.
He went to the
itself.
6th grade and then went to work in the coal mines then, or something like that, or was it, maybe that time was not covered. He had a 6th grade education,
Exactly right, Your Honor.
and he went to work in the coal mines, according to this, when he was 24 years old.
Yes, Your
Do you
Honor.
know what he did between the time he dropped out of school?
He was a veteran, Your Honor. I believe he did some military
He
service.
was in the military service.
Yes, sir. With regard to the inference or their statement that it would be quote-unquote completely unrealistic for him to go beyond the bounds of what's contained on the form, well, first off, he did exactly that. We were talking about climbing. The form does not ask about climbing. He filled in climbing himself, so he already knew that he could go beyond the bounds of the form and wasn't limited by the questions that were stated there. Second, I think it's important to note, Your Honor pointed out the application goes along with an employment history and they call the CM-913, I'll call it what it is, it's a description of coal mine work. All three of those were submitted at the same time. It appears that the envelope submitting them is from March 6, 2018. and the corresponding envelope comes from the Rennell Medical Center Black Lung Clinic. Now, the purpose of a black lung clinic is to help people who want to file a claim for benefits get help filing the appropriate forms. Now, I'm not saying this is dispositive proof that that's where it came from, but it at least calls into question the inference that Mr. Cavendish was going at this on his own education and completing this
But
form. Fine.
in this posture, can we go beyond, like the ALJ didn't say anything about that. Can we look at that if that wasn't the basis for the ALJ's decision in this posture?
No, Your Honor, I would strenuously maintain that we should defer to the ALJ and her factual findings. But I raise this simply to point out that the claimant here wants to assert additional facts and wants to make additional factual arguments. And I would imply that if this court adopts that, this court runs the risk of itself making a mistaken determination of fact. The ALJ considered all the evidence. The ALJ weighed all the evidence. The claimant doesn't get a different inference simply because they would like it to be so.
Can
We
I-
should have.
Sorry, I just had another question. There were a couple of things I was having trouble following in the ALJ's decision. One was the weight on this form. And then the other was this thing about the foot controls. Because the ALJ, like, he didn't write in here anywhere, also I use foot controls, but the ALJ was, it seemed to me kind of treated the exclusivity of what's written on the form differently. The fact that he didn't write in, I lift heavy things, was dispositive, but the fact that he didn't write in, I use the foot pedals, was not. And also, what about the hand controls? Why did the ALJ think he uses foot pedals but not hand controls? I was just very confused about the whole foot control thing.
Yes, Your Honor. In our opinion, it appears that ALJ Dom essentially gave the claimant the benefit of the doubt to a large extent and was willing to assume some rigors even if they weren't clearly established
But
there.
why not assume the one that his wife testified to if you're going to do that?
If I could address the foot controls first, and then I'll turn to the testimony if Your Honor will allow me. Concerning the foot controls, I will note that while there's this argument that it should be medium, under the Dictionary of Occupational Titles that the claimant wants to be applied, even though the judge is not required to, the description of light work, and this was not unfortunately cited in the block quote from the claimant's initial brief, does include foot controls. It states a job should be rated as light work when it requires sitting most of the time, but entails pushing and or pulling of arm or leg controls. So even if that's accurate, it's still light manual labor. The second issue with regard to her testimony.
Oh, no, I'm sorry, what about the hand controls? Like, I assume if he used foot pedals, he also used hand controls, and all the charts seem to treat those as different things.
Under the light work, it's both of them, Your Honor. I apologize if I misread
No,
that.
but so why didn't the ALJ say, how did she come up with foot controls but not hand controls? That is my question.
Likely, like I said, Your Honor, she was giving the claimant the benefit of the doubt to assert additional rigors. It's our position that he did not establish that. With regard to Mrs. Cavendish's testimony, I think it's important to note that that is the only evidence of the weight of the battery in the record here. And it's indirect evidence that, as Your Honor pointed out, the ALJ is not required to credit that. And it's also important to note, one, Mrs. Cavendish indicated she never went and visited Mr. Cavendish in the coal mine. And two, she obtained this idea of the 80 to 100-pound battery from a statement Mr. Cavendish made to his physician, which she then saw in the physician's note, and then recounted in a deposition years later. So this means that the statement went from the minor to an unnamed physician whose report is not of record, likely to a medical transcriptionist, was then supposedly seen by the claimant at an unknown time, and then recounted again years, if not decades later. The ALJ is not required to give this dispositive weight. She would not be required to give this dispositive weight even if it came from the minor himself. Your Honor, continuing with the exertional rigors, I would like to touch on a couple comments about Dr. Sood and Dr. Allen. First, as Your Honor's noted, ALJ Dom did give diminished weight to Dr. Sood's opinion, and that's because it was inconsistent and based on generalities. Dr. Sood agreed in deposition testimony that for some bulldozer operators he's spoken to, their job is no more strenuous than simply sitting on a cushioned seat. Now, in his deposition testimony at page 697, he says that for most, this is not true. But this means that for some, it is true. And while this is inconsistent with his later testimony that the medical literature establishes that even jobs that sound sedentary may have additional rigors, the ALJ doesn't err by according less weight to his later hypothesis.
But that's not what the ALJ says. This is inconsistent with his assertion in the form that he never lifted things occasionally. And I guess I have the same question I already asked, and I genuine question. Can we go beyond, like in this posture where we're reviewing for substantial evidence, are we limited to what the ALJ relied on? Or can we say, well, what the ALJ said was not supported by substantial evidence, but we've come up with another way to justify this outcome?
The ALJ did indicate that his opinion was based on a hypothesis, so this is completely consistent with that. Essentially, the statement is that Mr. Cavendish is not a statistic. Even if most coal miners might do this work, it doesn't necessarily mean that he did.
Yeah, but the
And-
ALJ relied very heavily on what the expert is saying. The reason I know this coal miner didn't do that is because of what is not written down on the form.
That was one part of it, Your Honor, and she also said that the claimant didn't put forth any credible evidence to establish additional rigors. Dr. Sood, she didn't credit because it was his hypothesis. Dr. Allen, she didn't credit because Dr. Allen misconstrued the exertional rigors of the claimant. She didn't credit Mrs. Cavendish's speculation about the weight for the reasons I stated. And there was the mention of the state claim benefits. An ALJ is not required to defer to a state claim finding. Plus, at most, all that establishes that is that at one time he helped lift a battery. It doesn't establish the weight of the battery, and it doesn't establish how many people were helping him.
Can I ask why it matters whether he was helping or not? I mean, it was heavy enough to put out his back, so it seems like the more people who were helping, probably the heavier the battery was. I guess I'm not understanding why that's a good fact for you, that even though he wasn't doing all of the work, it was still enough for him to injure his back.
Yes, Your Honor, and that was addressed by the claimant in their petition to the board. They had argued that the battery must be heavy because he hurt his back. What we noted there is they're presumably much younger than Mr. Cavendish, as anyone of some age, and I can certainly attest to this. Even sleeping wrong, you can hurt your back.
Right, I'm sorry, but why does it matter how many people, why does it matter how many people were trying to lift the battery at the time this happened? That's the part I'm not getting.
Because the weight of the battery would then be divided among people. So even if you assume it's a 50-pound battery, if there are 5 people helping lift, that's only 10 pounds.
I see, and so if you assume that every time he lifts batteries, he's doing it with this same number of people.
Well, all that's established is that maybe one time he helped lift batteries. And that's, I'm in total agreement with you, Your Honor. The record here is not clear on what's established, so that's why we should defer to the ALJ's finding. Your Honor, I'd like to touch base as well on some of the reasons.
The only one of these doctors that had seen this fellow was Allen, right?
Correct, Your Honor. And in the claimant's brief, they infer that Dr. Allen should thus be given some special weight because of that. But I'd note that while Dr. Allen did perform the Department of Labor-sponsored examination, there's no specific evidence that she talked with him about the exertional rigors of his coal mine work. Now, often that history is taken by a technician. The record does not establish whether Dr. Allen had any additional conversation about Mr. Cavendish's coal mine work with him, and indeed, what she wrote down concerning his coal mine work is consistent with the miner's description of coal mine employment. Dr. Allen just considered it differently than the ALJ did in terms of what Mr. Cavendish did, because there was this talk about Dr. Allen seemed to imply that he was walking around for 8 to 10 hours. I know that some issue was taken with that, but it's important to note.
But Dr. Allen had seen him and talked to him, met with him,
Correct, Your Honor.
and the ALJ had not.
Correct, Your Honor. But the ALJ is not required to give Dr. Allen dispositive weight. She has to consider all the relevant evidence. And I agree that if you pick a piece of evidence and look at it in isolation, there are inferences that can be drawn from it. But that's not what the ALJ is supposed to do.
Oh, I'm sorry, thank you. So I'm going to try one more time to ask this question, because I'm genuinely not sure about the answer. So the ALJ says, based on the claimant's assertions on the CM 913 form, I find that the claimant's last coal mine job as a dozer operator did not involve significant lifting or carrying. I want you to imagine, hypothetically, I don't think that the form supports that statement. Can I go and look at other things that might in the record? Can I, on my own, go do that, or am I kind of stuck with the ALJ's reasoning?
Your Honor, we should defer to the ALJ's reasoning. Additionally.
Okay, so if I think that sentence is wrong, I should send this back? If I think this form is not substantial evidence that he did not do any significant lifting or carrying, what should I do?
Your Honor, the evidence has to be considered in total. We can't just
Okay, that's what
pick one piece of evidence.
Sorry, that's what I'm asking. So even if I think that statement, I don't think this form can carry that weight, so to speak. I am free to go through the record and see if there is some other substantial evidence that would support the bottom line here.
If I'm understanding what Your Honor is saying, I think it is important to look at the evidence in total with regard to the ALJ's finding. So this court's duty is not to pick one piece of evidence and say an inference could be drawn for the claimant, so therefore we'll send it back. I think it's also important to note that this burden of establishing the rigors of coal mine employment rests with the claimant. So even if there's no evidence whatsoever that's credible, the claimant still fails to carry that burden. And I did want to touch base briefly on some of the reasons the ALJ accorded Dr. Sood's opinion less weight. If we get into the merits of it and their medical determinations, I'd note that I personally took Dr. Sood's deposition, and therein he has a number of credibility issues. He went back on some of his statements, and the ALJ took that to heart when she was analyzing his opinion. So this is going beyond just looking at one test and assessing that test. The ALJ took that and looked at his opinion in total, just like I'm urging this court to do.
Well, but it says, again, that he persisted in opining total disability based on his hypothesis regarding higher rigor levels than attested to in this form. And based on that, I find that his opinion is entitled to little weight. It just seems like it all comes back to the form over and over again.
That was one aspect of the ALJ's decision to discredit Dr. Sood. There's a completely separate aspect of it as well. She noted that Dr. Sood, in that laundry list, changed his opinion with regard to whether the testing was qualifying under the DOL standards, changed his opinion concerning how the American Thoracic Society standards would apply, and the ALJ cited that in her decision.
Sorry, what page are we at?
In the ALJ's decision, that would be, in the joint appendix, the deposition itself is...
Oh, no, I'm sorry, in the ALJ's
Oh.
opinion.
Sorry, that'd be page 43 where she's talking about the medical determinations.
Okay.
Or page 43 of the joint appendix, excuse me. And that cites to pages 723 and 733 of
Gotcha.
Dr. Sood's
Thank you.
deposition testimony. And the same is true for Dr. Allen. The ALJ didn't just look at Dr. Allen and say, well, these tests don't qualify, so I'm going to accord Dr. Allen little weight. The ALJ looked at it in total and said, there are other reasons to discredit Dr. Allen.
Where was Dr. Allen practicing medicine? Where was he from?
Your Honor, candidly, I don't recall from the record.
Was he a neighbor, was he like in that county? That's in Nicholas County.
Your Honor, I believe Dr. Allen is female, and I'm not sure where she practices. I
Okay,
apologize.
It's a she,
Your Honor, in closing, I maintain we have to look back and note that the administrative law judge is the fact finder here. We have to defer to her findings, and she considered each of the ways in which the claimant can establish a totally disabling pulmonary or respiratory impairment. She noted the pulmonary function testing does not qualify under DOL standards for disability. She noted the arterial blood gas testing does not qualify under the Department of Labor standards for disability. She noted there's no reasoned opinions of cor pulmonale, Dr. Sood's suppositions to the side. and noted that the medical opinions did not establish total disability. All we're talking about here is a subpart of a subpart, and even with that, she noted there were other reasons to accord those opinions of Dr. Sood and Allen diminished weight.
Is it the government's position that the 30 years or so of underground mining is irrelevant?
Your Honor, years of coal mine employment is always something to consider. In this case, Your Honor had mentioned the 15-year presumption. Even if the requisite years of coal mine employment are established,
I'm talking about and I'm particularly talking about the underground mining. That's where it's dusty, or dustier. But you're not taking the position, the government's not taking the position, that's irrelevant.
well, first, just to clarify, Your Honor, I'm here on behalf of Landmark Corporation as insured by the West Virginia Co-workers Pneumoconiosis Fund.
Well, the director is a party here, you were trying to uphold them, yeah.
Yes, Your Honor. And with regard to the underground coal mine employment, the ALJ did not reach a determination concerning the years because it wasn't required. A requisite element of entitlement under the
But
regulations.
on these forms, that's what it shows.
Yes, Your Honor. Mr. Cavendish did have coal mine work, and it did appear that some of his coal mine employment was underground.
Well, underground, I mean, from 1964 to, on the first page to 1987, everything he did was underground.
Yes, Your Honor.
23 years, and then you go to another page.
And to get to that presumption, you need to prove both the underground coal mine employment and a totally disabling pulmonary or respiratory impairment. That's also this element of entitlement that she did not establish. Your Honor, and I see my hand is up. If there are no further questions from the panel, I'll take my seat.
We appreciate it.
Thank you.
Thank you very much. Ms. Burgess?
Yes, Your Honor. I'd like to start out by mentioning that on JA 013, ALJ Dom says that the CM913 is not fully reflective of Mr. Cavendish's job duties. And then what she does is she looks to outside information, the Dictionary of Occupational Titles, which she took official notice of. She looks to that definition to find items, different duties that he did at that job, including, we believe, foot controls is where she got that. Dr. Sood's expert opinion also mentions foot controls and hand levers. In this case, we believe we've carried our burden of showing that Mr. Cavendish was totally disabled. We presented evidence that of Dr. Allen saying that it was light to moderate work and he was still totally disabled. Dr. Sood saying that Mr. Cavendish was totally disabled and he did light to moderate work with occasional heavy work exertion. We presented 2 state claims that state that Mr. Cavendish had to lift a dozer battery and he hurt his back lifting that dozer battery. And we've also presented Mrs. Cavendish's testimony, which is supported by the state claim. It's also supported by Dr. Sood's expert opinion on what a bulldozer operator actually does, Your Honors. What I'd also like to mention is that when you look at the CM913, Judge Dom is finding assertions where there are blanks, where it does not ask what one does on a date. It only asks what one does on a daily basis. It does not ask what that person does occasionally. And she's finding assertions where there are blanks. And we just ask that you return this to the ALJ so that we can get an opinion that is supported by substantial evidence, Your Honor. Thank you.
Thank you very much, Ms. Burgess, and thanks to your group at Worsted and Lee. We'll come down and greet counsel and then go on to the next case. That's all. You can be seated. I'm sorry. We'll wait for council to change. Take your time. Take your time. In our second case this morning, we have United States versus Nutter. Mr. Coleman, good to have you with us. Good to see you again, Mr. Coleman.
Thank you, Honor. It's good to see all of you. May it please the court. I represent David Nutter. He's a 57-year-old ex-Navy veteran. He lived in Somerville, West Virginia, had been married 30 years and raised his wife's 3 stepdaughters. He was a laborer for the majority of his life after getting out of the Navy. He spent most of his life in Ohio, and then for 13 years before his conviction in this case, he had moved again to West Virginia. My client's possessed, in violation of 922G9, a squirrel rifle, 2 shotguns, and a revolver. What they didn't count were 3 muzzle loaders that had been his wife's father's, but these were family guns. This isn't a case where he went out and bought anything illegally or did anything nefarious with the guns. His criminal history went back to 1998 when he pushed one of the 16-year-old stepdaughters in an altercation and pled no contest to that in Ohio. That was a misdemeanor conviction. Then
Mr.
4 years
Coleman,
later,
If I
sir?
could ask you at the outset, what you're bringing here is a facial challenge to the statute.
I'm bringing both, Your Honor. I'm bringing facial
Where
and
do we
as applied.
find your as-applied challenge?
Well, this was my first Bruin case. This was the first one our office had. And we went through the structure of that text in the case and didn't differentiate with labels. We argued about the age of his convictions throughout as mitigating against the statute applying to him.
Well,
Most of my argument, yes, was.
what I'm looking for is either where you told the district court we're making an as-applied challenge and here's why it is, and where you've told us in your briefing you make an as-applied challenge and here's our argument.
I made that in the supplemental memorandum, parsing it out. It was made together the way the case was written throughout. When Bruin was first announced, and I know our magistrate and district judges were saying it didn't even apply in a criminal case because that wasn't what was before the court. So, other than arguing the facts of the age of his past convictions and what they were, we didn't do anything
Well,
really beyond
I mean,
that.
to me, at least, that's a significant distinction. Because I'll have to say, I'm not finding a specific as-applied argument in your supplemental briefing, at least.
I do not have the page number before me. When opposing counsel argues, I will look for that. I did
All right.
make the reference, but I also find the two so convoluted, other than notifying you we're making both, I think they both apply.
Because in a facial challenge, all the government has to do is show a circumstance where the statute can apply.
That's true. I don't dispute that. And Rahimi made that clear. Bruin did not. Bruin, means and scrutiny evolved out of
Right, but a facial
Salerno's.
challenge is a facial challenge. I don't know that it's any different under
I agree.
the Second
I
Amendment.
agree. That's not in dispute, but I would point out 2 things. Well, one I'll save. But Salerno was very closely tied to means and scrutiny, necessarily.
But-
And when we got rid of means and scrutiny, Bruin was very opaque to where Rahimi had to correct it and say, hey, we still are doing Salerno, which was after Nutter was filed, argued, and originally briefed. I mean, in the briefing,
But
we've
before
gone.
your supplemental brief, I mean, you had a chance to brief this case after Rahimi, right? I'm sorry, isn't your supplemental brief after Rahimi? or
Yes,
am I-
ma'am. Yes,
Okay,
ma'am.
so
Yes, ma'am.
Rahimi made clear, like, whatever thoughts anyone might have had about Salerno, after Rahimi, it's clear, like, we're just doing regular Salerno here.
I think that's what
Okay.
Rahimi's left us, yes, ma'am,
Okay,
yes, ma'am.
but, okay.
I-
And you had a chance
I
in
have a
your
diff-
supplemental brief to post Rahimi, say, now we understand these are two different things, and we are bringing both a facial and an as-applied challenge.
Yes, ma'am, but they're
Okay.
so heavily integrated, we felt there was enough noting the age and type of conviction in the midst of arguing the substance of Bruin and how it applied to the statute.
Okay.
There was no intent, certainly, and no abandonment or forfeiture of the issue.
Well, as to a facial challenge, the Sixth Circuit recently decided a case called Gales,
Yes, sir.
and would you say in that circumstance that the statute was inappropriately applied because the convictions there were not old and cold and were multiple, and they were all violent?
Yes, I will, and I will start with a concept I want you to think about during oral argument with opposing counsel and when you're writing whatever opinion you do. With Hunt and with Canada, other statutes, there's been a lot of talk, and with government briefing going back, God, to Heller, that the Second Amendment only applies to a law-abiding citizen. We had, with Chester, going forward through Staten and the other opinions, we had a different two-pronged test. And then we all started focusing with
Well,
text.
I don't think the government's contending that Mr. Nutter's not part of the people for Second Amendment
I don't think they are
purposes.
now, and I think you're right. But looking at the historical analysis, the consideration, starting consideration should be with conduct. Anything that goes back, I'm mentioning for the first step, and then we'll get off of it. I suggest you look at it as conduct of a law-abiding citizen. In other words, what they are doing, what we've identified in Heller as a conduct that's protected by the Second Amendment, what a law-abiding citizen does with that gun, not who's doing it. The argument has gotten conflated, distracted in a lot of lower court cases in this circuit and in others, looking at, well, who? And in Chester, we even got into it at one point. If Staten didn't say it, Hamilton did, that, hey, we're in step one, we're not gonna look at what they're doing with the gun, we're looking at who has it. I
Okay,
wanna suggest
So
to
that's
you,
not what we did in Hunt, right? So,
not eventually, correct.
right, so, and we're bound by Hunt, so I wonder if we
We
could
are.
move on. Okay.
All right. But the of by distinction matters. All right, getting to Hunt and answering your question about Gales. Gales was concerning me for two reasons. A lot of it is based strictly on observations Justice Sotomayor made in her concurrence, but more importantly, this concept, this overgeneralized concept of dangerous people, and how the historical analog, I mean, really, let's acknowledge, right now, we're at the step two in Bruin. That's what this appeal is about, whether it's gonna be facial or is applied to Mr. Nutter. This is where it's migrated since the
Right.
original briefing.
Rahimi, rightly or wrongly, seems to give a fairly broad brush to the capability of the government to restrict firearm possession by people that are deemed to be a threat to public safety. And they go into some detail on the surety laws, both English and colonial, and the affray laws, French, English, and colonial. There were probably some significant historical errors in the Chief Justice's opinions, but they're the Supreme Court, and they've told us what the law is. And the Congress has made a determination that people who commit these domestic violence acts are a threat to public safety. So why is that inconsistent with Rahimi?
Rahimi looked at surety laws aimed at limiting domestic violence, which had nothing to do with guns, or if one got forfeited, it was a gun you had at the time. It didn't totally ban the right to arm and defend yourself or to get
Right,
food.
I agree, I think you're right. I think
Affray
there-
laws.
I think there are historical errors in the court's opinion, but it says what it says.
It does. It also says with the affray laws, which are just committing a crime with a gun. That's what going around and terrorizing the public with a gun is. And we haven't seen affray laws really stay on the books because all these other crimes over the past two centuries have displaced them. So, but all it says is with respect to a temporary disarmament, it says during the period of this order. And you don't even need a counter order for it to, it just expires. If you don't go on to something else, when the order's in effect and it goes away with the case, there's no more disarmament.
Okay, but
It's
what ab-
temporary.
okay.
Well, I grant you that in a proper as-applied challenge, but I'm not sure how the temporal element figures into the facial challenge.
Oh, it has to with that. Because all the writing Justice Roberts did was to justify a temporary disarmament.
Okay, then what should I do with Hunt? Because Hunt, of course, said no as-applied challenges to felon in possession permanently.
This isn't a felony.
Well, I know, but Hunt covers a lot of nonviolent felonies. So Hunt says, let me just finish.
Yes, ma'am.
Hunt says that there is a tradition of doing this on a categorical basis, not an individualized basis, and doing it permanently. That's what Hunt says. So you have now both Rahimi and Hunt to get through, and I think Hunt is a real problem for you in trying to rely on the permanent nature of this bar.
Respectfully, Your Honor, felonies were distinguished from the beginning of the colony, so much so that 6 colonies with their charters had expressed provisions to enact less sanguineous criminal laws. I had to look it up. I didn't know what it meant, but it meant you didn't kill so many people for the laws they broke. When you go back to Hamilton, which Hunt says is still good law, we're still getting that, a felony represents such a departure in judgment that no one later can ever be trusted with having a gun again. That's not a misdemeanor. And if there are no guardrails or distinctions with this is what Justice Thomas pointed out in the Rahimi dissent, which just because it's a dissent doesn't mean it's applicable here, because Roberts didn't contradict it. We don't have any guardrails if we go the way the government has argued in this, or if we take Hunt to its extreme. And I don't know necessarily that that panel intended it to go to that extreme. They were definitely laying something out for felonies and leaving open the door for, it was kind of like felony equivalence when that term was used with Chester, moving up before Bruin. And now we've got, while the emphasis in Hunt was definitely on felons, you're right, there's this other part that's open, but that wasn't pertinent to the decision, was it? That didn't decide it. That's easily dicta, just like the presumptively lawful.
I'm sorry, which part of Hunt is dicta?
Beyond being convicted of a felony.
Okay,
The generalization that legislatures, and a lot of that relies on state legislatures that were not even subject to the Second Amendment at the time they passed laws making categorical distinction. Our law allows categorical distinctions. I'm not disputing that. But which ones and to what degree? How do we measure what is a dangerous person the way Gales talks about?
well, I think we let the legislature do it, right? The legislature made a judgment that this is a dangerous category of people. Just like in Rahimi, they made a judgment.
Which historically goes beyond what was done at the time of the founding. We still have to, post-Rahimi, do the same
I think
how
you're
and
probably
why.
correct on that, but the Supreme Court decided it anyway.
It did.
And we have to go by what they said.
And they said we have to do the same why and the same how. The why, we can see a merger of and consistency with. You can't really debate that. The how is what's violating the historical precedent. We didn't start disarming people permanently till 1934. We didn't start doing this with domestic violence misdemeanors till 1996, a time when Bruin even says is not even historically relevant in
I thought you
determining.
just said the why you agree, like there is a historical tradition of disarming people for this purpose.
No,
Because they are deemed dangerous.
All right, then I wasn't clear with what I was saying.
Okay.
There was an historical acknowledgement of the problem through surety laws of having them post a bond if they felt there was that threat.
But there were disarmaments en masse during the colonial period. If you
Well,
were enslaved, if you were an American Indian, and some colonies, if you were a Catholic or some other particular so obviously we wouldn't do that today, but at the time of the adoption of the Bill of Rights, there was this history of disarming entire categories.
Which is what brought the Second Amendment around with the text it has. We had a period of time of 20 to 40
But
years
that's
in
just
there.
flatly foreclosed by Hunt. Hunt says we can look to that tradition of categorical disarmament. I mean, we are bound by Hunt.
But-
I understand you think Rahimi is wrong, you think Hunt is wrong, but that's not a luxury that we have in deciding this case.
But the part of Bruin, Your Honor, that is not missing is that it still requires a well-established and recognized tradition. If we take principles so open-ended that you do what Gales did, which was say it doesn't have to be related to the same why at all. They disarmed that group, so that's okay. They went through.
That's also what we did in Hunt. And maybe you think that was dicta. I wasn't really clear on which parts of Hunt you thought we could excise as dicta.
Felon, I felt, based on some of the authorities cited and the fact that it went beyond dealing with the issue before the court, which was,
No,
is a
it really
felon,
didn't. It
can you
really
disarm it?
didn't. The Hunt panel relied centrally on this history of disarming as a categorical, just done deal. Everybody in this category is disarmed. Hunt relied on that. It's its
It did.
reasoning.
It did.
Okay.
But this is a different category. We're calling this a misdemeanor. The state laws do it. Congress did. That means something, or what's the point? If you're going to do it to misdemeanor domestic violence, then what about the person who violates a parking meter? What about the person who drives too fast and endangers lives on the highway? What's the proper proxy for dangerousness? This is not an adequate proxy for dangerousness, looking even at Mr. Nutter. It was 17 years ago. He did under what offense? Boise has said this can be done how? Recklessly. The plate against the wall. The second conviction.
What was the full beer can at the baby? Was that reckless or was that intentional? When he threw the full beer can at a baby?
Half-full beer can was at the adult and deflected
that's
and
not
hit
what
the
the-
child,
Oh, so
is my understanding.
aiming at the adult but hit the baby.
It hit near the adult and deflected. Yes, people were hit. That's not in dispute. I'm not minimizing that.
Well, it seems like you are.
No, but compared to what? Compared to felony convictions, which again, at the time of the founding, had you executed. They wouldn't have done that necessarily for a bar punch or for even hitting, not right or wrong. But it's called a misdemeanor for a reason. It's under the code federally. And then we get to Castleman where it's an offensive touching. We're going to deprive people of a fundamental constitutional right for their entire life on what elementally, if we do it categorically, looking at 922G9, what does it actually boil down to when you get to the case constructions? A misdemeanor crime of domestic violence is a crime that has as an element the use or attempted use essentially of offensive touching that can even be done recklessly. That's what Voisin and Castleman put together, give us with that statute and that definition. And that, under any combination of historical analogs, doesn't seem to satisfy the Bruin requirement, even under a relevantly similar analysis, that it be a well-established and recognizable, even as a principle. How far, what are we going to define violence as? What are we going to define danger? This was the same problem we had with responsible in Rahimi and the way the court reacted to that. I don't think Hunt addresses that. And we don't have any guardrails or standards to define if dangerous is going to be it. If the courts are going to be adopting a dangerous standard, measured by what? We don't even agree on what physical injury requires, state by state, or even federally, depending by crime. And in the misdemeanor context, physical injury is not even what the common man would look at as a physical injury at all. And people are convicted of that. And yet the Congress, in 1968, as developed then later all the way up till we finally included domestic violence misdemeanors in 1996, 20th century mechanisms are now defining the historical scope of something that was enacted in 1791. And what I'm seeing, Your Honors, that is concerning me is not the deference due the Second Amendment that the Supreme Court intended, but more an enshrinement of familiar gun regulations that we all know. The fact that something's unfamiliar to us with this, applying the law consistently, is not necessarily a bad thing. And if it turns out to be, Congress then can act and do it further and have it continue to be reviewed pragmatically through the process that was contemplated by the founders setting up our system. And then when Justice Marshall did what he did with Marbury versus Madison.
we've been really generous with the
You have
time.
been, and I'm over it.
You recognize what that red light means.
I do. I was trying to get your questions. If there are no more, I'll sit down. Thank you.
You save some time. Mr. Glazer?
May it please the court, William Glasser for the United States. I'd like to start where Mr. Coleman left off, addressing the sort of scope of Section 922G9 after Castleman and Voisin. There are certainly,
Let me ask you the same question I asked opposing counsel. Is this a facial challenge that's been brought, or do they have an as-applied challenge?
Your Honor, we understand it to be a facial challenge, and he does say on page 2 of his supplemental brief that it's both facial and applied, and as applied. I think the problem is that, as you mentioned, he hasn't actually developed any sort of as-applied argument that would apply to him specifically, and I think this is where the sort of Castleman-Voisin riff is just really beside the point, because what we have here is an application to Mr. Nutter where he was not convicted under a Castleman or Voisin doctrine. He actually knowingly used force, and the force was the kind of violent force that would qualify even outside of Castleman. Knowingly used violent force not once but twice when convicted of these domestic violence misdemeanors. And all this court needs to decide to resolve his facial challenge is that it has some constitutional application. Now you could sort of hypothesize a constitutional application, or you can just do as the Supreme Court did in Rahimi and say it's constitutional on its face because it's constitutional as applied to this particular defendant, Mr. Nutter. I think that's an easy way to go, because
Could we simply say it's constitutional as applied to Mr. Gales? I mean, that's
Sure.
a circumstance.
Your Honor, yes, you could certainly do that. You could hypothesize, and Gales is I think a good example of someone to whom it can be constitutionally applied. But we also think it's constitutional as applied to Mr. Nutter, and that is another way that you could get there. Again, as I mentioned, the parts of the Ohio Code under which he was convicted require knowingly causing injury to the victim, and so that's not reckless, and the way that injury is defined there lines up consistently with the type of violent force that is required outside of which is above and beyond the common law battery context. If I could then turn to this court's decision in Hunt and how that might interact with Rahimi, we think that essentially, although Hunt dealt with felonies, essentially the combination of Rahimi and Hunt foreclosed Mr. Nutter's argument here. Rahimi established that those who have committed domestic violence can be disarmed, at least temporarily, consistently with the Second Amendment. And what Hunt does, above and beyond that, is say that it does two things. It says that Congress can make the determinations as to who's dangerous. It doesn't have to be a judicial officer, as it is in the context of 922G8, the provision at issue in Rahimi. And secondly, it says that Congress can make these determinations sort of on a categorical basis, and this court doesn't need to consider as applied to every particular person whether or not that person is dangerous. So the court said in Hunt, past conduct can warrant keeping firearms away from persons who might be expected to misuse them. And we think that the statistical evidence, common sense, even the court's decision in Rahimi indicate that Congress could conclude that persons convicted of misdemeanor crimes of domestic violence are dangerous and that they are likely to misuse firearms. I would point out that Section 922G9, the definition of a misdemeanor crime of domestic violence, is not quite as broad as in the context of the Armed Career Criminal Act. So it doesn't extend to simply the threatened use of force. It requires either the use or attempted use of physical force or the threatened use of a deadly weapon. So it's a fairly narrow provision that applies only to misdemeanors where there has been force that is used, attempted to be used, or where there's a threatened use of a deadly weapon. So this is not going to reach to all misdemeanors. It's only a narrow category of violent misdemeanors, and Congress could conclude, based on the statistical evidence, that people who have committed these crimes do pose a danger, not just to their family members, but to others if they're allowed to be armed. Although the facts in this case are somewhat in dispute, I think Mr. Nutter is a good example of a good example of why Congress could make that judgment. So there were 3 corroborated accounts by minors in this case that Mr. Nutter pulled out firearms, swung them around while intoxicated, bragged about being a felon. Now, the district court didn't resolve that factual dispute, and Mr. Nutter denies that he engaged in that conduct. But one way or the other, 2 days later, when the sheriff's deputies executed a warrant at his house, they found these firearms. So we think that Mr. Nutter is squarely within the group of people that Congress could determine are dangerous if allowed to be armed. If I could just make one final point, I think that the decision in Gales does a good job sort of describing the interaction between Rahimi and, in that case, binding circuit precedent on G1. And I think this court's decision in Hunt does something similar. And I think there's a couple of sort of inferences that this court can use to extend, and we recognize it's an extension of Hunt to the facts here. If you look to the historical analogs that Hunt relied upon, Hunt relied, for example, on the fact that you could forfeit firearms for non-capital crimes. So Hunt referred to colonial-era offenders who committed non-violent hunting offenses and were still ordered to forfeit their firearms. If someone can be disarmed for a non-violent felony based on the rationale that it's a serious offense and that it's dangerous, then I think for the same reason, someone who has committed a violent misdemeanor can be disarmed based on a dangerousness rationale. So for those reasons, we think that the historical analogs, as discussed in Hunt and in Rahimi, are more than sufficient to justify Section 922G9 under the Second Amendment. If the court has no further questions, we would ask the court to affirm.
Thank you very much, sir. Mr. Coleman?
I'd like to thank my appellate counsel for digging up the joint appendix. The references to an as-applied challenge, Your Honors, Joint Appendix 11 in our motion to dismiss, Joint Appendix page 15, Joint Appendix on page 24 in the government's response, Joint Appendix page 35, and Joint Appendix 104.
But where's your argument to that effect in the supplemental brief?
Other than referencing that we're making both, I don't elaborate on it because I've considered them both conflated. But that's where we had brought them up in the record before that, and just the undisputed circumstances with him. As far as inferences in Hunt, hunting violations in England were the forfeiture of the weapon you were hunting with. You were not denied permanent firearm rights. You lost the value of the gun.
Again, I understand that you think Hunt was wrong, but Hunt thought that was a relevantly similar historical tradition to disarming felons not allowed to have any weapon. So
Yes, Your Honor.
it would be most helpful to me if we kind of stuck to arguments that aren't foreclosed by our circuit precedent.
Well, I'm agreeing with your point. I don't know that it necessarily forecloses it with misdemeanors. I would equate a misdemeanor more with a hunting violation. I'm not trying to misread Hunt. I know it was relied on that was good enough to disarm felons, but that law, as it was construed in the opinion, was never a permanent disarmament. The sheriff and the king would seize the weapon. They could go buy another weapon. When Catholics were disarmed, they were not disarmed from protecting their home. They were disarmed from having a weapon, carrying it publicly, and it was the same. Native Americans were banned from buying guns, not possessing guns, and Native Americans and slaves were never citizens, or were not until after the American Civil War, when Congress Indians were the last people who were designated that way. So at the time of the founding, they were not part of the people textually protected by the Second Amendment. So that in part justifies why they thought it was okay to disarm them, even temporarily, and it was temporary. Catholics and non-loyalists could renounce certain things and the government would give their guns back. They did that, the why, to stop an insurrection with a new country during the middle of the Revolutionary War and the period after it, not because of some generalized public dangerousness, again, which is undefined and has no guardrails. Looking at Ohio with Gales, injury in Ohio is defined as anything, even offending or hurting your feelings. It's that broad. It doesn't take a physical injury the way the state defines it. But we're looking at 922G9 and how the federal government defines that. and that does require at least an offensive touching. People, can we categorically disarm people suspected or concerned about misuse? The courts are the only guardrails I know to put on that. And looking at history, who we say, Hunt is very broad, and anything I would suggest that doesn't directly apply to felons, in other words, to lesser things, look how open-ended that is. Again, if we're gonna use that in Hunt to extend to the misdemeanor, in this type case, where does it stop? That's my concern. That, again, goes to, we're enshrining existing regulations, fine. We are not showing the deference the Supreme Court intended to the Second Amendment. Thank you. I'm sorry, you were drinking, if anybody's, I'm, you're absolutely right, Judge Harris, I'm not pretending Hunt
I didn't
doesn't
say
exist.
that.
It's a big rock, facially or as applied.
Okay.
But I don't think it stops the as applied challenge, certainly as to Mr. Hunt. And that too, I would ask. If you're not prepared to acknowledge the facial challenge and sustain that, at least with respect to Mr. Nutter, those facts that my colleague related to you were in a PSR and were disputed, and Judge Berger did not rely on them in the sentence she imposed and in rulings she made in the case. They were allegations in the discovery. We were prepared to litigate them. The government did not bring witnesses. It was not resolved factually. What was not disputed was, since 2002, the only other conviction he'd had was in 2007 for driving without a license. Nonviolent, nothing, and then from 2002 until 2019, he hadn't done boo. I'm out of time. I appreciate your indulgence.
Thank you, Mr. Coleman. We appreciate it. We'll come down and greet counsel, and then we'll take a short break. We appreciate your work. seated. In our next case, we have Knockout Holdings versus Kakar. Mr. Werner? Yes, Your Honor. Good to have you with us, Mr. Werner.
Good to be here. Thank you for having us. Morning, Your Honors. May it please the court, Paul Werner on behalf of Knockout, also known as Octo. Octo brought this lawsuit for defamation against Mr. McCarr because in an effort to kill a $1 billion transaction with IBM, he said Octo's management were liars and lied to him. They pushed him out of the company. They
So
did not
we're in federal court here under a diversity of jurisdiction,
Yes, Your Honor.
and so your opposing counsel and parties say that we don't have diversity.
They do, and they're mistaken.
All right,
They-
tell us why.
Sure, Your Honor. They raised that argument based on some K-1s that Mr. McCarr received about a year before he found this jurisdictional defect. And here's the issue. Mr.
Does
McCarr's
that make a difference? I mean, either we have jurisdiction or we don't have
That's true.
jurisdiction.
You're right, Your Honor. They're free to raise it at any time. However, it does go in my view, to the merits of the argument because it is belatedly raised when they should have known about it and could have raised it much sooner. But to the merits, the reality is this.
What about the jurisdiction? Do we address it here, or that we have to send it back to the district court?
Your Honor, I think the court can address it here because I don't think it's very difficult.
It wasn't raised before.
It was not raised before.
We have jurisdiction under section 1291 of the code to review a final order. That's what we got up here.
Yes, Your Honor.
But the district court, the diversity jurisdiction issue would be something for it initially, wouldn't it?
Your Honor, we point out in our brief, if there are doubts about jurisdiction, they can and should be treated in the district court as an initial matter. However, because they were raised here in this court can entertain them as an initial matter and can decide them here based on the evidence that's of record. And I was just getting to that. The evidence of record.
So we would have to weigh the evidence and in effect discount the K-1s, which indicate that this entity would have still been a Maryland resident, which would destroy jurisdiction if that's accurate.
Your Honor, if the court believes that it needs to weigh evidence, I agree with you, it needs to go back to the district court. Our argument is
Is that evidence even properly in this record?
There is sufficient evidence in this record for the court to determine jurisdiction.
Well, I mean, the K-1s, they're attached to your brief, aren't they?
They're not attached to our brief, they're attached to
They're attached to
our
the brief.
opposition's brief.
They're
And
attached to a brief.
Yes, and the court admitted
They're
them
an
into the
exhibit to a
record.
brief. What is, pardon?
This court admitted them into the record, so they are part of the
Well,
record.
there was an order that did, but they weren't in the record. They were not in the record in the district court. And there was no motion made under Rule 10E of the Rules of Appellate Procedure to supplement the record. Our clerk entered an order letting you attach them to the brief. That attaches them to the brief.
You're right. We didn't attach them to our brief. In fact, we opposed their motion to attach them to their brief.
But they're attached to a brief,
They are. You're right.
and the briefs are based on the record made in the district court.
The briefs are based on.
That's the way the process is here. And if you need to, if there's something missing from the appellate record, there's a rule, I said, Rule 10E, that authorizes a proper motion to supplement or correct the record. And that rule was not utilized here.
You're right, Your Honor. And again, if there are questions about diversity of jurisdiction, those are properly treated in the district court, and we note that in our brief. However, based on the record before this court, the court can assure jurisdiction based on two things. One is the IBM transaction that is at the record at JA 791, which makes clear that Mr. McCarr is not a member of Knockout Holdings at the time that we filed this lawsuit and any time thereafter. Also, I would point the court to the records around the repurchase of Mr. McCarr's shares, which are at 752 through 762 of the record, which indicate and make clear, and there's no disputing this in the record before this court, that his shares were entirely extinguished more than a year before this litigation was filed. Now, he does point to certain K-1s, and the K-1s are important for this court to understand, but all they reflect is an economic interest, not a membership interest. And we identified the relevant
Well,
tax
isn't
laws.
that a question of fact, though, assuming it's properly before the court?
It is not a question of fact,
Well,
it's a
why not?
question of law. We pointed to the IRS regulations at 1.736 and 7.61 that indicate what is going on here with respect to the K-1s.
Right, but
K-1
the K-1s reflect a profits and loss interest, a capital interest, and the New York State one, as I took it for 2023, indicated a continuing ownership, which may or may not be correct, but while there could be an economic interest under the partnership rules, I grant you that, could also very well be a pure membership interest. And I think the point is, we don't know at this point.
Your Honor, there cannot be a pure membership interest, because if you look at 791, there is no equity held by the defendant in this action in the plaintiff. That had been extinguished. And again, I point to
The
share
K-1s say
repurchase.
there is equity.
The K-1s say that because it's a quirk of tax law. Even when a member's interest has been extinguished, it's still reflected for purposes of taxes until that economic interest has been fully redeemed. It has not been fully redeemed here because there remains a note outstanding for the purchase of Mr. Kakar's shares that he has not fully redeemed. That is what is reflected in the K-1s. I understand if there's a question of fact around that and this court isn't comfortable determining that on this record,
Well,
then a
didn't the
remand is
Delaware-
proper.
Didn't the Delaware court find there was a disputed issue of this fact in the state court proceedings?
Yes, so far the Delaware court has held that Octo, knockout, properly triggered its right to repurchase Mr. Kakar's shares. There remains a question around whether there was a breach one way or the other with respect to that repurchase. However, no matter how that legal issue is determined, the shares have been extinguished. So it's a breach of contract. It does not trigger any default or change in his ownership of the shares. The shares have already been extinguished. It becomes a matter of breach, and it becomes a matter of damages. In fact, we know that to be the case because the estimated damages are already in escrow with the Delaware court around that share repurchase. I'm happy to continue to talk about jurisdiction if there are further questions. Otherwise, I'd like to move to the merits.
Go right ahead.
Okay. With respect to the merits, the district court simply got it wrong, and in doing so, announced and applied a troubling rule that IBM would take Mr. Kakar's statements with a grain of salt because they were not dispassionate or impartial. In reaching that conclusion, the district court applied the wrong law, Potomac Valve, which was essentially overruled by the Supreme Court in Milkovich, as this court recognized in subsequent decisions like Biospherics. All of the current law, Milkovich, Biospherics, and other cases from this court and the Virginia Supreme Court make clear that when assessing whether a statement is actionable, the words matter most. You look at the language, you look at the context, but fundamentally you are assessing the words to determine whether or not they are verifiable, whether or not they are provable.
But Biospherics, I read Biospherics as pretty consistent with what the district court did here. First, you ask the threshold question, is verifiable or not, and then both Potomac Valve and the decision we're looking at here and Biospherics say even if it is verifiably true or false, depending on the context, it may still be opinion. So I'm not really seeing where there was kind of a legal error here.
Well, Judge Harris, I think the court in Biospherics looked both at the words as well as the context, but
Right.
the words and the context there, in that case, the court was assessing, are very different from the words and the
Well, I
context
know, but
here.
your threshold argument is that, wow, the district court just applied completely the wrong standard. And I take the point that the district court cited Potomac Valve instead of Biospherics, as it should have. but I don't see the district court applying a standard any different from what we applied in biospherics. But I want to give you a chance to tell me
Sure.
if you think there was sort of, that this is not just semantic, that there was a substantive failure to apply the right standard.
Your Honor, I think the difference is really the frame of reference. In biospherics, and as the court in Milkovich said, you look at the context to assess whether the context actually negates whether the words can be taken seriously as verifiable. And in biospherics, of course, the court found that they did, because the words themselves also were cheeky, they were tongue-in-cheek, they were cute, there were plays on sugar and the like, and the court ultimately held that this is a breezy stock tip in a stock-picking magazine. Unlike in Milkovich, where you have accusations that a wrestling coach perjured himself in a serious article in a newspaper, or even like in Potomac Valve, where you have a competitor's newsletter there where Judge Wisdom recognized that, yes, these may be verifiable in some sense, but no one is going to take them seriously because they are in the heat of conflict and competition in a competitor's newsletter. Those circumstances are very different from the circumstances here. The words that Mr. Kakar used took direct aim. They were black and white. Octo lied. Octo pushed me out. Octo was not honest. Octo cheated me out of shares and the like, and Octo lied to IBM and has secrets and will lie to IBM and not honor its promises to IBM. Those are black and white statements said for the factual statements that they were, and they were in a serious context. They were intended to disrupt and undo a billion-dollar transaction with IBM. They were made by somebody who was a senior executive with the company. He was an insider, he was a shareholder, and a prior shareholder, and an owner. And they were made in the context, again, in where he was already filing lawsuits. He had an interest and he had inside information, and he was sharing it and working his way up the management chain at IBM in an effort to get to somebody who could hear him out and undo the transaction. Those facts are very...
Comments or statements that are attributed to Mr. Kakar don't seem to me to be that different from any number of pleadings that you would see in situations like this where there's some business-type divorce. And it's concerning that, following your reasoning, you could turn almost every dispute like this into a defamation claim.
Well, of course you do. There is a privilege for litigation that applies in the context of pleadings made with courts. But the statements that he made were not, I've alleged they've breached a contract. That's a far cry from what he alleged here. What he alleged was that they lied. That is a direct aim at Octo's reputation and character, and within the heartland of defamation claims. Whether it's said or repeated in a lawsuit is irrelevant. That freestanding on its own, and there's no case law that's suggesting that simply because you say something in a lawsuit and then repeat it outside of litigation, that it can't be defamatory. But here, the allegations that he made don't simply track the allegations that he made in his complaints. His complaints talk about breaches of contract. They talk about equity. They talk about the share repurchase. They don't say that Octo lied to me. Octo lied to me is a core defamation statement, whether it's made in a lawsuit or otherwise. But here, it's very different. So it's not simply like this is a lawsuit that we are challenging the statements that he made against us to bring legal claims. These are statements that he made to senior executives at a counterparty for a billion-dollar transaction in an effort to sink the deal. Your Honor, I'd like to touch on a couple other points that were raised by my friend on the other side of the aisle in their brief, really for the first time as alternative grounds. One argument that they make is that Octo failed to allege or prove the exact words. That's an argument that this court and district courts throughout the circuit have rejected repeatedly, and Virginia courts have rejected too. Rule 8 governs the pleading standard. We are not obligated to either prove or plead the exact words that Mr. Kakar said. However, even if the court were to import Virginia law into Rule 8, which it shouldn't do, we have proven more than sufficient words that Mr. Kakar said that are defamatory about our client. And I'd point the court to JA 200 through 209, and that's the deposition testimony of Ms. C.C. DeCamp, where she no fewer than 8 times says that Mr. Kakar told her that Octo lied. Those are more than sufficient words, even if the Virginia standard applied, which it properly does not. Another argument that they raise is this of or concerning, where the statement's really of or concerning Octo. Well, the record makes clear there's no mystery around who Mr. Kakar was talking about. He was talking about Octo's management. Ms. DeCamp also recognized that at JA 08, where she says Octo leadership. There's no question who Mr. Kakar was talking about. He was talking about IBM's counterparty, and he was talking about IBM's counterparty to IBM executives. All of them perfectly well understood that Mr. Kakar was talking about the party whom they were doing $1 billion deal with, and that was Octo and its leadership, which are housed in the plaintiff knockout. Lastly, let me just note, in terms of the declaratory judgment, it should go the way as our claim. It should be reinstated as well, because we do seek prospective relief around the party's rights and obligations. Happy to answer any further questions, Your Honors.
You've saved some time.
Thank you.
Mr. Rainsbury?
Good morning, and may it please the court. Joe Rainsbury for the appellee, Sonny Kakar. I will address the jurisdiction argument promptly, but first I wanted to correct a couple things from the presentation of my colleague across the aisle. There is no evidence that Mr. Kakar ever said the word liars. There's no evidence that he said that Octo, whether Octo Platform or Octo Consulting, cheated him. These were inferences that Ms. DeCamp drew from what Mr. Kakar said. And we don't know what Mr. Kakar said, and that is really the fundamental problem of this case. And I need to remind the court that this was before the court on the district court on summary judgment. So they had an obligation to come forward with evidence. And it is part of Virginia's substantive defamation law that you have to prove the exact words. So this isn't a pleading problem. This is a substantive problem with their defamation claim. Now, with the subject matter jurisdiction question, I know the court has concerns. And I will tell the court that this is not an argument we wanted to raise. We want an end to this case, too. And we think our arguments are strong, and we'd like the court to dismiss or to affirm the dismissal with prejudice. But there is a concern over subject matter jurisdiction.
You have raised this question.
Beg your pardon?
I say you have raised this question.
We have raised because we have to, Your Honor. As an officer of the court, we have to raise the issue.
So what puts, in lieu of our Rule 10, what puts the K-1s properly before us?
Well, at any time, a party has to raise a problem with jurisdiction. And this was not part of the district court record, so I don't think it was properly, it's something that needed to be supplemented or corrected. This is something that, frankly, it occurred to us only while we were making an argument in the Delaware case. We were arguing that this is exact estoppel argument. And then sometime when we were in perhaps September, the penny dropped.
You had the K-1s in the Delaware case?
We did. I think discovery had closed right around the time that the district court issued its, in the Delaware case, right around the time the district court issued its opinion in this case. So we had them. But the penny didn't drop until August or September. And I apologize for that, but I mean, it's just what it is. I think the court does have both the power and the obligation to determine jurisdiction at this point. And I'll remind the court that it's the other side who has invoked federal jurisdiction. And
Do you think we should decide it in the first instance?
Yeah, it's a matter, it's just a legal matter, Your Honor.
But we're a court of review.
I understand, but you.
Not first view.
I understand, but you still have to satisfy yourself of your jurisdiction.
We're talking about jurisdiction of the district court.
Well, this court's jurisdiction is derivative.
We're talking about jurisdiction of the district court to have done anything in this case.
Well, if the district court didn't have jurisdiction, then this court doesn't have jurisdiction, because 1292 is derivative of the district
We
court's.
have jurisdiction under 1291 to hear the
That's what I-
appeal.
thank you.
That's what we're doing here today.
Right. Okay,
And what
well,
do we do with the appeal? Do we affirm it, reverse it, throw it out on basis of lack of jurisdiction, which is what you want us to do? Or do we have authority, since we do have, some way or another, whether they're here properly or not, these documents?
you got these
Do
documents.
we have authority to remand it for a jurisdictional inquiry? We could, that might be
That might, first of all, we're not asking you, the court, to do it. We're just saying that this is a problem.
well, I'm asking you what to do. You're a lawyer.
I understand
here,
that.
And you're the one who stirred this up. 'Cause
Yes,
You're the one that filed
yes.
the papers.
So
And
there's,
and the clerk filed the papers with your, or with your brief. Your brief is here, and it's
yes,
got an exhibit to it,
yes.
which aren't in the record properly, I don't think,
It's not in the district court record,
but
correct?
they're here.
Yeah, there are items in the district court record that go to the same question. And, for example,
What are those?
there was the attachment to the April 15th letter has it has a copy of the operating agreement. And the operating agreement says,
So
it
go
gives
back,
the,
what's the April 15th letter?
I'm sorry, the April 15th letter is a letter saying, we intend to repurchase your shares.
All right,
Okay, but there's no evidence that the shares ever were repurchased, and they weren't. And there's no evidence that the shares were ever canceled. There's no evidence that there was ever any transfer of shares by Mr. Kakar back to the company. So,
and the Delaware court didn't decide that
did not
issue.
decide that issue, correct, right.
Is it still before the Delaware?
It is still before the Delaware court. I think trial's in September. So, our point is basically that there's no dispute about the authenticity of these K-1s. What these K-1s say is that Mr. Kakar is a member. They raise this separate IRS regulation that concerns retirement or death of a partner. That's not what happened here. This concerns a repurchase of shares pursuant to the operating agreement. But there's no evidence that any money has changed hand or that the shares have been returned or canceled. So just because, when we think that the court can determine this because it's simply a legal question based on documents of undisputed authenticity. I mean, the court could send it back as well, but there would just be, the district court would be presented with the identical legal argument. All right, well, with the court's permission, I'd like to turn to some of the defamation points raised by opposing counsel. We submit that the court should, on merits, affirm the district court's dismissal of the defamation claim. And again, this defamation claim, the issues arose in the context of a summary judgment motion. But nearly all the evidence of the defamation is Ms. DeCamp's testimony. And that's at JA 197 through 215. And I urge the court to reread that and to see whether or not this would amount to defamation under Virginia law. Now, the law of defamation is well settled. I mean, I think the Supreme Court of Virginia said you need an inducement, a colloquium, and an innuendo. Basically, you need to know what was said, you need to know who it was said about, and you need to know what was meant by it. And Knockout's defamation claim fails on all 3 points. Most fundamentally, they can't say what Mr. Kakar said because their only evidence is what Ms. DeCamp's deposition testimony, and she doesn't remember what he said. She just remembers the gist of it. They can't say who it referred to. They say Octo. Well, there are 2 different Octos. There was Octo Platform, which is who they represent. But then there's Octo Consulting, which is the entity that IBM purchased. So they can't bring a defamation claim on behalf of Octo Consulting. So it really does make a difference who Mr. Kakar was supposedly talking about. And Ms. DeCamp doesn't know. I mean, she didn't even know the difference between these entities, so she couldn't possibly know who he was talking about. And then the third problem is, well, what was meant by what Mr. Kakar said? Was he just voicing his unhappiness, his opinion that he had been unfairly treated and that he has a valid legal claim, which is under Virginia law opinion, under federal law, under the First Amendment law, just opinion, or, you know, was he saying something substantive? Now, the district court resolved the issue on the first question, and probably the most straightforward one. You just look at the context. I mean, you read Ms. DeCamp's statement about the call, and the context is clear. This is a guy who was kept completely out of the loop of this big purchase, even though he was a significant shareholder of Octo Platform. He learns of it, and he's shocked because he knows he's got a big lawsuit against these guys, Octo Platform, that is, and he is just astonished that this transaction could go forward with IBM's knowledge of that litigation. So, you know, his inference is, well, if they don't, they must not know about it, and so they must not have been told about it. And all of that is clear from the context of what Ms. DeCamp says. That's what she says he called her about. And with respect to the claims that Mr. Kakar implied that Octo, whoever that Octo was cheated him, and again, the word cheated is not, was not Kakar's word, it was not DeCamp's word, it was just counsel's word in a question. The context of that makes it clear that he's simply stating his legal opinion. I mean, he was promised certain things under these agreements, and he claims that they didn't honor their agreements, and he's upset about it. And Virginia law is clear. If you look at the Shaker case, one of the most recent Virginia Supreme Court cases on defamation, it says, you know, a complaint about a statement that somebody has violated an easement or violated a contract or done something of that sort is not the sort of statement that has the requisite defamatory sting that could be a defamatory statement. So for all these reasons, we submit that the district court properly looked at the context of the statement and properly determined from that context that Mr. Kakar was simply stating his opinion and that these statements were not defamatory and that because the statements themselves there was no evidence of what he said, that he couldn't, I mean, for this alternate reason, that Octo could not establish that Mr. Kakar defamed them. And so for all those reasons, we respectfully request the court, you know, either dismiss this action for lack of subject matter jurisdiction or in the alternative, affirm the decision below. Thank you.
Thank you very much, sir. Mr. Werner?
Your Honor. Just a couple points on rebuttal. Going back to the question about jurisdiction. If the court has doubts about jurisdiction, the proper approach for this court to take is a limited remand back to the district court for assessment of jurisdiction and determination. Assuming there is jurisdiction, then the appeal can go forward on the merits. If there isn't jurisdiction, then as we offered in our brief, the appropriate approach is for the district court's judgment to be vacated. I'll reiterate again that there is evidence in the record as it stands showing that Mr. Kakar's shares were repurchased. That's at JA 755. The K1 reflects that repurchase. If you look at the 2002 K1 that's attached to the brief, which admittedly is not properly in the record at this point, it shows that Mr. Kakar's shares were repurchased for $28 million. That's the same price that's in the note. And then if you look at 791, which is the deal documents for the IBM transaction, there is a capital table provided that shows all of the membership interest of all the members of the LLCs, and you will note that Mr. Kakar's holding company, Seva Holding, is not among them. That is because his shares have been extinguished, and they will never be returned because the value of Knockout Holding has effectively been reduced to cash as a result of the IBM transaction. That is why in the Delaware litigation, the value of Mr. Kakar's former shares have been escrowed. If he prevails in that case, which he shouldn't, he would receive cash. He would not receive shares. His shares are gone forever. And you didn't hear opposing counsel argue otherwise. That is enough to provide this court to have jurisdiction, but if there are doubts, the case should go back on a limited basis.
So what did the Delaware court decide to date?
So to date, it decided that under the deal documents between Mr. Kakar and Knockout and various other entities, Knockout had the right to repurchase his shares, and it properly exercised that right on Mr. Kakar defaming Octo under the terms of the agreement. So far, the right has been triggered. The only thing remaining for the Delaware court to determine is whether that was done correctly or not. And whether it was done correctly or not.
Whether the repurchase was done
Whether
correctly?
the repurchase was actually carried out consistently with the terms of the agreement. And this is what I was getting at earlier when I said it's really just a breach and damages question. The shares are gone. We had a right to repurchase them. The Delaware court has determined already we had that right and we properly exercised that right. The only remaining question is, did we go through the procedural rigmarole to actually carry that out correctly? If we didn't, then that goes where it goes, and if we did, then we did. But whether the district court rules one way or the Delaware district court rules one way or the other on that doesn't matter for jurisdiction purposes here. The shares are gone.
So you don't see any issue preclusion problem coming out of the Delaware court?
No. No, they're distinct. If I can just make a couple points getting back to the merits discussion we were having. And I too hope the court reads the joint appendix. I'm sure it already has, but I will call the court's attention to a couple statements in Mr. Camp's testimony. JA 200, they were not truthful individuals. JA 202, Sonny did share concerns that about the Octo team being truthful. JA 207, I recall more they lied to him. They lied to him. There was lying involved. Those are the very statements that the Milkovich court held are defamation and are actionable. There, you will recall that the Supreme Court says, in my opinion, Jones is a liar is an actionable statement. They're not even couched as opinions here. Mr. Camp is simply reciting what Mr. Kakar told her.
But doesn't she also say, and this is what the district court relied on, I thought, that she understood him to be describing his litigation claims against the company? That was the context as she understood it. He's describing why he's suing and what he's suing on.
Her discussion is not just in the context of the litigation. Of course, the litigation is a backdrop that is going on, and that is something that he was insistent on trying to bring to IBM's attention, but was not just about the allegations of the litigation.
Right, but that was, as she understood it, the context of the conversation was that he's in litigation and I'm hearing why.
There's nothing in that context that negates the seriousness of what he was saying in terms of it being factual and verifiable. It's not like Biospherics, where it's just a breezy stock tip. It's not like Potomac Valve, where this is just a competitor trashing another competitor's testing in their own company newsletter. This is a former senior executive board member and former shareholder talking about his experience with the Octo leadership and saying they lied.
I mean, in your words, trashing the company with whom he's in litigation. I mean, that does seem, it seems like the district court has at least a serious point here that given the context, one might understand that these are legal opinions.
We don't think that includes all of her statements and we don't think that that encompasses all of what she recited that Mr. Kakar told her. And I think if you read the deposition fairly read, it's wide-ranging, and she does talk about the litigation, but she also talks about Mr. Kakar sharing his experience with the Octo
So
leadership.
is it fair to say that where you think the district court went wrong, I mean, you talk in your brief a lot about the legal standard, but basically you think the district court misread the deposition testimony, that it wasn't really all about, it didn't all come within this litigation context?
The district court certainly misread the deposition
Okay.
testimony, but that is not the full extent of the district court's errors. The district court also applied a precedent that has been overruled by the Supreme Court and pronounced a rule that defamation isn't defamation if it's not impartial and dispassionate.
Well, that's not really how I read it. I read the district court saying, look, maybe saying these are verifiably true or false statements, but that the context is a description of ongoing litigation, and because of that, a reasonable listener would understand these to be opinion.
We don't think there's anything that's in that context that actually negates the fact
Right.
that he was stating facts.
So it really comes to how you read the deposition, it seems to me, but you don't have to agree. Okay.
Unless there are further questions, we will request that the court reverse the district court or remand back to the district court. Thank you, Your Honors.
Thank you, Mr. Warner. We're going to come down and greet counsel in this moment, but before, I want to explain to the fellows from VMI that we're going to take about a 10-minute break for a conference of the court, and then we'll return to the bench and have a discussion with the visitors if they're interested enough to hang around. We'll come down and greet counsel, and then we'll step out for a few minutes.
This honorable court will take